The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined today by Institute for Justice attorney Robert Everett Johnson, as well as Clark Neely of IJ's Center for Judicial Engagement. If you like what you hear, be sure to subscribe to our weekly email newsletter at ij.org/short-circuit. This week on the show, ride sharing in the sky, the downside of medical marijuana, and the taxman cometh for legal marijuana businesses. Clark, kick us off.
First case is out of the D.C. Circuit. It involves a really interesting situation in aviation that's very similar to what's happening with ground transportation, with Uber and other companies kind of disintermediating or at least displacing taxis. So what's happening is that you got these companies that have sprung up that use the web to put together private pilots who are going to go out for a flight with other individuals who might want to tag along. Maybe the pilot's going to go out and just fly, from an airstrip outside of New York up to, Maine or Vermont. Somebody wants to go there anyway and offers to come along and pay part of the expenses, pay the gas, for example. Does that make someone who is otherwise clearly a private non-commercial pilot, does that transform that flight into a commercial flight, which would require a higher level of licensing on the part of the pilot under the Federal Aviation Administration's scheme of regulations? Very interesting question.
Yeah, and I think there are two things that you have to be really clear on here. One is that these pilots aren't making any money by doing this. They're just getting a share of their expenses. And the other is that they could do this without being on the internet. They could post on a bulletin board, say, I'm looking for somebody to come along with me on a flight. And the FAA has already said you can do that without becoming a commercial pilot.
Yeah, and people familiar with administrative law will probably not be surprised to find out that the FAA has not really put out any clear regulations on this. They seem to be regulating on the basis of advice letters and other informal guidance. And this interesting dynamic develops in the case where it seems that the FAA is sort of allowed by the court to decide whether or not they're going to consider this informal guidance to be binding or non-binding. And because it looks like it's going to help them win, they decide they'll go binding. And basically what it seems to come down to in this case is two factors. One is the private pilot holding himself out as willing to basically take passengers, people who are not friends, people who are not relatives. These are just random strangers who want to come along for a ride. So that's the first question, holding out. And second, is it reasonable to characterize when somebody helps pay your gas, for example, is that compensation? Because those are really the two issues that are that help determine, or they're going to determine, whether this is purely private or commercial. Are the pilots holding themselves out as willing to give a ride to anybody? And does paying your pro rata share of gas and maintenance and so forth constitute compensation to the pilot?
Rob, those are the questions before the D.C. Circuit. What did the circuit say?
Well, what's odd about this case is that you would think that the FAA has already answered these questions. The FAA has a rule where they say that when a pilot does this kind of thing, as long as they're getting a pro rata share of their expenses and not actually making money off it, they can do that without having to have a commercial license. But the FAA, in a letter to these companies that want to have this service, has said otherwise. And the D.C. Circuit says, well, we're going to uphold that because, it's an administrative agency and agencies can basically do whatever they want, and courts are just going to rubber stamp that.
It's as I said at the beginning, this is a really interesting parallel to what's already going on and has been going on for some time in the surface transportation area. Clearly, the government can't require you to have a chauffeur's license in order to just give a friend a ride to the airport. They can't require you to have a chauffeur's license just because that friend happens to give you some gas money for the trip to the airport. And so you get into a kind of a regulatory Zeno's paradox, right? Because the closer it gets to you're just acting as a taxi, and we can regulate you like a taxi. And the question really becomes, does the government have both a sensible place where they draw the line between private and commercial conduct, and have they drawn it in a way that is procedurally appropriate? So, for example, in this case, the plaintiffs, the company challenging the FAA's enforcement of its kind of non-regulation, claim that the FAA used to have one policy when it comes to these arrangements, and it has changed, and now it has another policy, and they shouldn't have been permitted to make that change without going through notice and comment rulemaking. The D.C. Circuit rejects that argument essentially because, that the earlier way they were doing things was an informal way of doing things, and so this new change isn't really a change in a rule. And to me, that really is the strangest part of the opinion in some ways, that the courts are allowing agencies to act as if they have an enforceable policy that everybody has to follow. But then when they change that policy, the courts seem to be willing to bend over backwards and say, oh, no, that was just an informal way of doing things, and you don't have to go through notice and comment rulemaking to change the way you're doing things. That really seems to give agencies an extraordinary amount of discretion, not only to interpret statutes and make up their own policies, but then to change those policies on a dime without receiving any public input. Very, very unseemly and unsettling approach to administrative law, in my judgment.
What does it mean for the economy when innovative services like this can't get an idea of what they're allowed or not allowed to do?
Well, yeah, that's a huge problem here, where you have a huge amount of uncertainty. And really, a part of the problem, too, is that you have companies that they know what they can or cannot do because they're being told by an agency in a letter. But that's not how the law is supposed to work. You're supposed to have a rule that's actually written out in advance, and that, as Clark was saying, is promulgated through notice and comment and the proper procedures. And agencies just making it up as they go along by issuing letters to people. That's not a rule of law. That's just a dictatorship by bureaucrats.
Maybe there's an opportunity for yet another entrepreneur to get involved here. Maybe what can happen is if there's a pilot who wants to provide a trip and someone who wants to get that trip, maybe the pilot could adopt the passenger, and then you could be related just for the period of the trip. And so you could have an entrepreneur who helps you with the legal arrangements. Now I'm the adopted son of this pilot. We're in the same family, but then I'm gonna be emancipated when we get up to Portland, Maine, so I can go on about my business. I'm just thinking out loud here. The serious part of what I just said is that technology does seem, in many industries or many areas, to be outstripping the ability of regulators to enforce, particularly nonsensical or unhelpful regulations, and that strikes me as all to the good.
Speaking of unhelpful regulations, we move now to the 10th Circuit. Rob?
So here we have a case that, as Judge Gorsuch puts it in the first line of his really well-crafted opinion, he says that this case owes its genesis to the mixed messages the federal government is sending these days about the distribution of marijuana. And that's, I think, really sums it up in a word.
Well, what you've got here is an interesting situation. Okay, so it's in Colorado. These people run a business selling marijuana in Colorado. That's legal under state law. It is illegal under federal law, but DOJ, under instructions from the president, has taken the position that it will not make enforcement of marijuana-related criminal laws a priority. But the IRS is lurking in the background. Why? Because you've got people running a business, and the question arises: can they basically write off business expenses related to their marijuana dispensing business?
As they would for any other sort of business.
Yeah, and you can imagine this is an incredibly important question if you're running a business. The IRS is saying that you can't write off any of your business expenses. If that's the case, you're going to have an enormous tax bill that may be greater than the amount of profit that you've earned in your entire business.
You said it was a well-crafted decision, Rob. What did you mean by that?
It's just really, it's a lovely piece of writing. Judge Gorsuch is just an excellent writer. The decision itself, at the end of the day, it turns into kind of a nothing burger. The court says that we're not actually going to reach the actual question that's presented here because we don't have jurisdiction, because it's too early in the case. It's an interlocutory appeal.
But the judge seems to get something off his chest, doesn't he, Clark?
Yeah, he goes right to the heart of this tension where you've got one federal agency that seems not to care particularly about the law at issue, which is federal criminalization of marijuana, and another agency that cares a whole lot, the IRS, mainly I think because forbidding people from taking tax deductions for business-related expenses ultimately results in greater revenue to the IRS, something they're always concerned about. I think lurking behind all of that in this case, however, is the problem that is created by the Supreme Court's non-enforcement of the doctrine of federally enumerated powers. None of this would come up if we had the proper interpretation of the Constitution, which does not grant the federal government a general police power, and the national criminal prohibition of marijuana is flatly unconstitutional, blatantly unconstitutional, notwithstanding the Supreme Court's ridiculous 6-3 decision to the contrary in the 2005 case of Gonzalez v. Raich. So this whole problem would go away if we just had what James Madison promised the people that we would have, which is a federal government of few and defined powers.
And of course, all that goes back to a decision that we probably mentioned before on this program, Wickard versus Filburn. I mean, this is an area of the law that the Supreme Court messed up in the New Deal and hasn't gotten right since.
Wickard being a case about whether the federal government can or cannot dictate to individual farmers how much wheat they can grow on their own property when they don't intend to sell that wheat and they don't buy anybody else's wheat. And according to the Supreme Court, yes, the federal government has the power to regulate even that purely local conduct on the basis that it is somehow related to interstate commerce. Once you do that, the whole scheme, the Constitution's whole scheme of limited federal power goes right out the window, and the Supreme Court is completely at sea every time a similar case like this one comes up. Why? Because the Constitution has nothing to say, not because it actually has nothing to say, but because the Supreme Court has essentially deleted the Constitution from the conversation, and we know what a disaster that has been.
So where does this case go next, Rob?
Well, it goes back to the tax court where the opinion really puts this business in a bind. They either have to turn over evidence that they are breaking federal law, evidence that shows that they are a marijuana business in violation of federal law, or they have to basically give up and eat this huge tax bill, and that's it's tough.
Yeah, and maybe I'll just add one more thing, which is that this is not the first time that the federal government has either attempted to or achieved changes in people's behavior, not by coming out and actually passing laws criminalizing various activity, but instead taxing activity that they do or don't want people to engage in. It's essentially using the tax code to treat all of us like little hamsters in a cage. And if you behave in a way the IRS likes, you get a little treat. If you behave in a way the IRS doesn't like, you get a little penalty. So from the IRS's standpoint, and from, I should say, Congress's standpoint, when it comes to tax policy, Americans are basically just a bunch of little hamsters in a box, and we operate on the basis of the financial incentives that Congress and the IRS see fit to extend or withhold. And as you can probably tell, I don't think that's a very good system of regulation.
And that's true, but this is also a case that arises from the weirdness of having a federal law that the president just isn't enforcing. I mean, and maybe rightly so, it's an unjust and bad federal law, but at the same time, it's Congress that makes the laws, and the IRS here is just enforcing the law as it's on the books. And this is something that Congress really needs to fix.
Marijuana prohibition is a non-serious law and increasingly being treated that way by the states. Whether the federal government will ever catch up remains to be seen, but it appears that at least the president and hopefully future presidents will treat it as non-seriously as it is.
It may be a non-serious law, but it does have very serious consequences. Moving on to the Sixth Circuit, Clark, you can tell us about some of those.
So the final case involves a father in Michigan who is, among other things, he's taking medical marijuana at the direction of his doctor. And that, together with some other conduct that's not really described in the opinion, causes Child Protective Services to get involved. What they do is interview the man's 5-year-old son at his elementary school without notice and without parental consent. The child services worker then files an application in court to have the child removed from the home. The father alleges that in that application, the child services worker makes a number of factual misrepresentations, and then after a court hearing, an order is issued for the child to be removed from the home. The father sues the individual responsible for initiating and completing the proceeding for essentially 3 things: for conducting an unconsented interview with the child, with his son, without parental consent in school. Second, for the alleged misrepresentations in the application to the court for the removal of the child, and then finally for the actual removal of the child from the home. And the question is whether the defendant, the Child Protective Services worker, is immune from suit for all of those things. And of course, people familiar with short circuit will immediately know the answer to that question. The answer is virtually always yes. Of course, because why? Because he works for the government, so he's immune from suit.
And is he immune in this case?
He is immune in this case, and actually one of the most amazing things the court says is that he, to the extent that this guy is working as a lawyer, as an advocate for the government, he is absolutely immune. So what that means is that he could walk into court and tell a bald-faced lie, and the court says this. He could tell a bald-faced lie in an attempt to take away this person's child, and it wouldn't matter. You could have proof positive that that's what he did and that he did it intentionally, completely immune.
Yeah, and just to be clear, absolute immunity is exactly what it sounds like. You cannot be sued no matter what you do, no matter how unethical or deceptive your conduct is. And perhaps the worst thing about it is this absolute immunity is a doctrine that is invented on the basis of another invented. There's no statutory grounds for this absolute immunity. The Supreme Court made up the doctrine of prosecutorial immunity, which is not specifically called for in Section 1983, which is the federal civil rights law. And then the lower courts have, by analogy, invented absolute immunity. They've extended this imaginary concept to other entities and individuals besides prosecutors to include even social workers. So you have a completely invented doctrine, absolute immunity, and then a completely invented extension of that doctrine to people like Child Protective Services workers that shields them from civil liability even if they have perjured themselves in court, have deliberately lied to a tribunal in order to remove a child from a home. I find that incredibly objectionable. Unfortunately, is perfectly in keeping with the direction of case law in this area, which is to constantly come up with new ways to ensure less and less accountability on the part of government officials. And if that was the goal, congratulations, Sixth Circuit, mission accomplished.
And the other thing you can see in this case is how the combination of immunity and standing doctrines can really put people in a box. This guy, they say, well, we're immune, the officer is immune, so you can't raise this claim.
So for the conduct that has already occurred, the individuals involved who took your child from you, they're immune from suit, so you can't get anybody going backwards. And then when he tries for prospective relief, which is a declaratory judgment on the constitutionality of this conduct, what happens?
Then they say that you don't have standing to raise that claim because it's too speculative that this is ever going to happen to you again in the future. So you can't go backwards or forwards.
Neatly distills the essence of so much judicial doctrine when it comes to government officials these days, which is heads the government wins, tails the citizen loses, through a combination in this case of a completely invented doctrine of absolute immunity for social workers, together with an avoidance doctrine in this case, standing to ensure that the individual who claims to have been harmed can't get any relief going forward. It strikes me the Constitution, one of the provisions in the Constitution that may seem really obscure and esoteric, is the one prohibiting titles of nobility for government officials. I would say that government officials who are couched with this kind of protection and enjoy complete immunity from whatever they do are, for all intents and purposes, a special class of individuals. They are, for all intents and purposes, the exact kind of nobility that so irritated the founders and that they thought was a bad idea. They are really a special class of citizen when it comes to the lack of accountability for their own conduct, and that is almost completely an invention of the judiciary. That is not to be found in statute. It is our judiciary that has decided that these people should not be accountable to citizens for their alleged misconduct, and I think that's really, really troubling.
I mean, can you think of anything more horrible than the government taking away your child, and yet here you have a court saying you have no remedy?
And if that's going to be done, and I'm quite dubious about that as a policy matter, let's at least have the legislature say that and say it clearly so that if people find it objectionable that someone takes your child away from you, possibly on the basis of lies and misrepresentations to a court, and then there's nothing you can do about it, that you can know for sure whose idea that was and who thought that was a great policy. And if you don't like them, you can vote the bums out of office. In this case, of course, that's impossible because the people who invented this policy are not legislators. They are Article III judges who enjoy lifetime appointments. That is not where policy should come from. Policy should come from legislatures, and the Sixth Circuit should be out of the business of inventing policy in this area when it comes to conferring absolute immunity on social workers.
Rob, where do things stand with the actual case now?
Well, so the kid is back with his father. The father has tried to get some sort of assurance from the court that this can't just happen again. And the court basically has said, no dice. We are not going to give that to you. So they have to live with that uncertainty.
And of course, the father continues to be a medical marijuana patient to the extent he continues to take medical cannabis to relieve whatever his symptoms are. It seems like he will be in jeopardy of having his child taken from him again. And of course, now he's very much on the radar screen of the relevant officials. Unfortunately, the judiciary's position seems to be, well, if it happens again, you can always come back. And presumably we will once again tell you, no, nothing that happened here was a problem. So I'd be very concerned if I were this father, very concerned about having my child taken from me again. And of course, the federal courts are going to stand by apparently and do nothing.
Okay, that concludes the show. Thanks for listening, and be sure to follow Rob and Clark on Twitter. Their handles are @FreeRangeLawyer and @ConLawWarrior. Until next time, this is John Ross from the Institute for Justice, inveigling you to get engaged.